Good afternoon and welcome to AM News Network presents Summary Judgment. I'm attorney Rachel Baird, joined by Ed Peruta. We're doing our live show, weekly show from the American News Media Center in Central Connecticut. What do we discuss on this show?
Anything and everything we possibly can.
And today we're going to be discussing the ins and outs of may and shall. Shall and may.
Well, okay. I think there's some things that we can talk about, but I'm going to ask Master Control to reach over to the wire that's hanging over the TV set and move it over that way.
It bothers you?
Yes, it bothers.
Why?
I think she can reach over the desk
and
she can move that little wire.
Okay.
There.
Little
and
insight.
I got to tell you something. I cannot thank the universe enough for our media director, Ariel. She is the glue that makes all of this work. Like coming to us and saying, guys, it's 2 o'clock.
Yeah,
okay.
She's been attempting to herd us down here for the last hour.
Here's what's happening. Let me explain. Did we do a show last week?
We did.
Did I have my surgery last week or after the show? Monday? Monday I had my surgery?
I do not know.
Okay. I had something called trigger finger. And trigger finger is when you make a fist and you open your hand, your finger stays curled, and then when you open it, it pops and it hurts. So they went into my hand this week and they cut a tendon of some kind. And as soon as they start cutting that one, this one starts acting up. But I went to the hand doctor, I went to the surgery center. They did it, I'm fine, I'm okay. But I had some time to watch some TV, taking pain medication. I am beginning to understand more about a saying that used to come out of a friend of ours, Peter Cook's mouth, more than ever. And he used to always say, refer to the law as the black letter law. I've always referred to it as the law as written. I've always said to people, you forced me to go to school till I was 16 years old. I went to school beyond that age. I do have a high school equivalency. I've got a couple of semesters of college that really, it wasn't for me. I've got a lot of life experience, but I do know how to read. And when I went to the police academy, they teach you how to read the law, the key words of the law, how to read it, how to implement it to keep yourself out of trouble. Stay within the law. Now, we at the academy back in the day learned shall, may, or, and. There were some key words. In other words, you have to have, there's 2 elements to the crime. A and B. So whoever you're going to arrest has to have done A and B to be arrested.
Mm-hmm.
But then there's the laws that say A or B.
Mm-hmm.
If you do one of them, you can be arrested. You don't have to do both of them. That's where and or the word or comes in.
Can I give an example of that without
Okay.
you losing your train of thought?
Well, I'm not going to lose my train of thought.
There's a statute in Connecticut called making a false statement to a police officer.
Right.
53-157B, I think it is, and we did a case where a client was charged with this. Well, there's two components. There's two elements to that charge. One is that you make a false statement, but that's not enough. And with the intent to mislead a public servant.
Right.
Now, presumably just because you make a false statement, it's not with the intent to mislead a public servant. So you have to prove both. And the Vernon Police Department at that time had a statement, a form statement for a suspect. And it provided notice on the statement that if you make a false statement, you're violating 53A-157B. Now, the part I forgot to tell you was there's an additional element of proof on making a false statement. Not only do you have to prove that the person made a false statement and had the intent to mislead a public servant, whatever they signed that you say is a false statement has to have notice of the statute
on the document.
written on the document. And the Vernon Police Department mischaracterized the statute, forgot with the intent to mislead a public servant, and I argued that my client should not be prosecuted for that because it didn't fulfill all the elements of the charge.
Right.
Judge denied that.
Of course. Now, so I learned those words. And my entire adult life, since I attended a police academy and learned those words, has been governed by what I was taught about interpreting the law and applying the law. You cannot imagine how many times I've come into a situation where I'm saying to a public official, it says it right here. Please read it. You shall do this, or we shall do that. I said that is what, the way it was described to me, is it's a command of the legislature, giving you no wiggle room. You shall arrest a person for domestic violence. You shall arrest both people in the house for domestic violence. There's that word shall. And then I started having people say, well, shall means may. And I don't know what court case could have possibly come up with may is the same as shall. But what happens is people start to ignore the way I was taught and start to come up with this new way of thinking that it could say shall, but it really means may and gives me a choice. And I sit there and say, this is why our country is beginning to evolve into something that it wasn't. Now, I went out...
I'm going to interject a theme that I commonly interject on this show, which is my theory that people don't change and how the act doesn't change. And when it comes to people's conduct, we really don't progress. We may progress technologically, we may progress in, medically and all these other things, but people's motivations and conduct doesn't change. That's my theory. And I can tell you, for as long as people have existed, they have been twisting the words of others to their own benefit. As long as lawyers have existed, which is probably about as long as people have existed perhaps, lawyers have been twisting words to their clients' benefits and for their own benefits, so none of this is new.
When I first met you, there was a client, no names mentioned, who was taken to the hospital and locked in a psychiatric ward. Couldn't get out. and the state police went to that individual's house and seized the firearms, then took the privately owned firearms back to the state police troop and put them in the locker. The risk warrant statute, enacted in 1999, has a very long legislative history and comments made by some pretty prominent people at the time. And they said, this is going to be abused. This will be abused. And in this case, and it still remains, the law says you obtain the warrant first, and then you seize the firearms. Is that not what it says right now?
Right, the warrant allows you to seize the firearms.
But you have to have the warrant according to the black letter of the law, the way it is written in the book.
Of course, they're looking to change it. I don't know what they're looking to change.
No, I know exactly what they're doing. You had to get the warrant before you touched and took the person's firearms.
Unless the person consented.
Unless they're consented or extended, whatever.
Exigent
circumstances. Okay? Now, that case and some similar cases went to appeal. And a judge says, I'm not going to be the one that rules on that. Take it to appeal. Have the appeal court rule on it. What's the matter, Judge? You don't know how to read the law? And again, I'm going to go back to Peter Cook. The black letters on the page that we know how to read say you have to do it this way. The state police, 2-3 days later, get us risk warrant when she's not a danger to herself because she's locked in a psychiatric ward. She's not in imminent danger of herself. And they go to the state police barracks and seize her firearms at the barracks, okay? Not at her house, because they've already seized them. So, no warrant. Now, this is not the first time that this has happened. But the courts came out and said, that's okay. Am I correct?
That may have been the first time that happened because back then they weren't doing that many risk warrants.
But it wasn't the last. It hasn't been the last.
But when the court said it was okay to do that,
they all started doing it.
Right.
Okay, because they cite cases saying, hey, you can take them. Now, Governor Lamont is now proposing, the current law says it takes 2 police officers to sign affidavits to apply for the risk warrant. But now, Governor Lamont wants any 2 people or family members to be able to sign affidavits to get the warrant.
So the way it read was, upon complaint on oath by any state's attorney or assistant state's attorney or by any 2 police officers, that's who could sign off on a risk warrant. But now it's adding, or other complainant who is a family or household member or a medical professional. So it's adding family members and household members and medical professionals, okay?
So here's my scenario. Somebody doesn't like me, knows that I carry a firearm, finds somebody else, they go to the police, they make a complaint, an arrest warrant is applied for, and an arrest warrant is issued. So they pick me up, and they may put me in an ambulance and send me to a hospital, based on the way my family says I'm acting. I walk into the hospital, and I'm examined by a doctor and a psychiatrist. They're waiting for me at the door. I go in, I talk to them, I explain what's going on, yada, 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 and they say, you're not doing anything inside of the ordinary. You're not, you're speaking. Go home. Now, the officer is going to apply for an arrest warrant.
Well, maybe not an arrest warrant.
Risk warrant.
Right.
He's going to apply for that risk warrant in the next 2 days, and he's going to present the facts to a judge. The one fact that he doesn't put into his application is, and Mr. Peruta was immediately transported to Hartford Hospital emergency room, and he arrived at 2:30, and he was discharged after examination by nurses, doctors, and psychiatrists.
Not only was he discharged, but we weren't concerned about whether somebody was going to pick him up or where he was going to go. In fact, he didn't have his car because the ambulance brought him here, and we told him he was discharged, and my understanding is he walked 4 miles home, which happens a lot.
Yeah. So what I'm saying is, by omission, they leave out exculpatory information from the risk warrant application. Would you consider the person was immediately discharged from the hospital and found to be okay by physicians and psychiatrists? Would you consider that to be exculpatory to the situation?
You know, I do, but on the other hand, playing devil's advocate, I see it as a sad admission by our court system that they believe hospitals on a routine basis, a daily basis, discharge people who probably shouldn't be discharged.
Ho, ho, ho! We have a whole fucking world now of catch and release in this country.
Yeah.
They're letting murderers out.
So it's a sad admission that our psychiatric system does not work.
Absolutely.
They're saying, you know what? Maybe the psychiatrist let him go, but that doesn't mean anything because hospitals, if you don't have insurance or you're irritating and you're causing trouble and we just don't want you here, we're going to throw you out, which we know that happened in one case.
When was Oklahoma City?
That courts admit that happens.
Okay. I'm going to assume... Okay. Now I'm going to tell a story, and sometimes Rachel gets upset. No, don't say it. I'm going to say this. I had reason to be upset with the Veterans Administration. And I walked into the federal building in Hartford, where the VA had its headquarters, kind of blew past everybody and went upstairs to the director's office and made the following statement, because I had been waiting for a decision on what's called my permanent and total disability status. And a person was sitting on my file, and I knew it was being sat on. But I walked in, and the female director got up out of her chair, and she's one of these, Ed, come back. What in God's name is wrong? And I said, does it take a fucking Ryder truck to get you people off your ass? This was 30 days after the Morrow Federal Building was blown up in Oklahoma. If the federal building was blown up in April, it was the middle of May 1995 that I walked into the VA in the federal building and said, does it take a Ryder truck to get you people off your ass? You can't say that. The VA police came up, the FBI was up there, the DEA was up there, everybody was outside her door. She held them off, and she said, tell me what's wrong. And I told her. And she said, if I do this, then I'm fine. And I got to go home. 3 days later, I got my answers. 3 days later, I got my decision. And the man who told me about it was a very prominent attorney by the name of Michael Gustafson. And I'm not going to say any more on it, but I was upset. And I made a statement. I had no intent to do any harm to a federal building. But I asked a question. Does it take people doing this to get your attention, to make you realize you're pissing people off? Let me ask you a question, Rachel. If I rented a Ryder truck, and nothing in the back, but I just kept driving around the city streets of Hartford, around the federal building, just kept driving around, somebody would notice that.
Yeah.
I'm sure I'd get pulled over and I'm going to obey every speed limit sign, every stoplight, every stop sign, everything. Somebody's going to pull me over and say, what are you doing? Where's the probable cause? What are you doing? I'm just driving around in a Ryder truck around the federal building all day and let all of the federal employees look out the window and see me. The world is going crazy when you can call up a government agency, whether it's local, state, or federal. You've read the law, you understand the law, you try to communicate with the government employee about the law and about maybe a requirement.
But here's the really disturbing part of what you're saying. We try to judge people on an individual basis.
Yeah.
And I think people should judge people on an individual basis. For example, one of the instructions in a criminal trial is there will be police officers testifying. Police officers are human like everybody else. They tell the truth, they lie, they do whatever. If a police officer testifies in this case, will you be able to treat his or her testimony like everybody else's? And some people say, well, no, because it's just so ingrained in me. When I see that uniform, it you know, I trust that person. I'm going to pretend to believe what they say more than what somebody else believes. Well, if you can't get past that, you shouldn't be on a jury, a criminal jury.
Right.
Some people may say the opposite. You know, they may say, you know, I've seen police officers do certain things and say certain things, and I can't get past that. They probably shouldn't be on a jury, but I want to make my point. So when I hear anybody say, you know, because of the way one federal employee acts, they're going to place the fear into other federal employees or do certain things. Because of the way, you know, one felon acts, they're going to judge all felons that way. Because of the way, you know, one lawyer acts, they're going to judge all lawyers that way. Because of the way one criminal defendant or one family court litigant or people who bring civil cases, we're going to, when we see one thing, we're going to say, that's how everybody in that position acts. And therefore, I'm going to have the attitude that I have towards this person, towards everybody else. And it's just so wrong. We need to get past that.
Okay, then let me counter with this. There's a bad apple in the VA.
Well, yeah.
And I'm sure that other people know there's a bad apple in the VA. And those other people who don't want to be bothered don't say anything about the bad apple in the VA.
Okay, well that's true of every organization.
Every organization. What I'm trying to say is this, is that let everybody start asking questions in the building. Why is this happening?
The problem is when you say it's like when you watch a television show or a movie and it's at a very simplistic level where there's a bad guy and there's a good guy. Okay, and nothing the good guy does is bad, and nothing the bad guy does is good. So it's really easy for you to take sides, okay? But life isn't that way. Some people are good one day, maybe not so good the next. They're very helpful to one person, not helpful to another. And so to characterize somebody as a bad apple, I think there are a lot of apples, and maybe one side of them's a little rotten, the other side is shiny. There's very few people that just you can come down and say good and bad. And so if you're going to get rid of everybody who ever does anything bad, you're not going to have anybody working anywhere in any agency.
Okay. One more quick one.
Okay.
I had reason to ask the Veterans Administration to copy my claim folder. Federal law gives them 10 days. Federal FOI gives them 10 days to provide the documents requested. I'll pay for them. Give me my documents within 10 days. I came back 10 days later. First of all, I saw them take my file and put it on the corner of a desk in the next room.
Mm-hmm.
I came back in 10 days. It's not ready yet. It's still sitting on the desk in the same place. I came back 20 days. Still sitting in the same place. I came back 30 days later, and I said, is my file ready? And the person who was talking to me said, and I don't even mind saying his name, it was Charlie Meacham. Very, very nice guy. But he says, nope, it's not ready yet, Ed. And I said, Charlie, let me tell you what the law says. And he pointed back at me and says, don't you tell me my job. That was like 8:31 in the morning. Okay? I got to 810 Vermont Avenue, Washington, D.C., the headquarters of the VA, in 5 hours. Driving like a bat out of hell. I don't think I paid any of the tolls. I was gone. I pull up in front of the building. I walk inside and I start screaming. Everett Alvarez, the longest held POW, was the secretary of the VA. He had a chief of staff by the name of Frank Fazinski. Frank Fazinski found out I was in the lobby and he came down. He says, Eddie, what's going on? And he took me into a room, little room off the office, and he says, Eddie, what's going on? And I said, Charlie Meacham. I says, I was kind, I was nice, I was everything. But Charlie Meacham put his finger to me and said, when I tried to tell him his job, he said, and he's right, he says, don't you tell me my job. I says, you know something, Frank? The problem is the conversation ended. He won the conversation. It's not my job to tell him what to do. It's your job. Frank Fazinski picked up the phone, called Hartford, got Charlie. It must have been 2:30 in the afternoon, 2:30, 3. Calls up Hartford, gets Charlie Meacham on the phone and said, did you have Ed Peruta in there this morning looking for his files? And he's holding the phone. I could hear it. He goes, yep. He says, well, when did he ask for them? Well, about a month ago. Well, why doesn't he have them? Well, we just didn't get to it. He said, you didn't get to it. Now, did he try to explain to you the 10-day rule? Yeah. And did you tell him it wasn't his job to tell you your job? He says, yeah, that's what I said. He said, well, I'm the chief of staff for the secretary. I have the authority to tell you what to do. You start copying that file right now, and you stay overtime until it's copied, and have it ready for him at 8:30 tomorrow morning. Do you understand? Yes, sir. And he hung up the phone. And so he expected I was going to drive back to Hartford and pick up the file in the morning. Well, I went down to Anacostia Naval Air Station and spent the night with the guys that flew Marine One, the president's helicopter. All of the guys invited me down to party with them, so I partied that night, and I didn't get home for a while. And so when I went up to Hartford, he had the package for me. What he said to the secretary on the phone when he says, I said it, and he said, well, that's not what he says, Mr. Meacham, Mr. Peruta is sitting in my office in Washington, D.C. right now listening to this conversation. You could hear on the other phone, how did he get to your office? He was just here. You know, like I got teleprompted down there or something. But they fucked over me by just, telling me, don't tell me my job. I'm telling you what the law is.
So do you want to get back to, with that in mind, get back to the may and the shall? So
the shall and the may.
So people have a better idea.
The shall and the may.
Okay. So there was a case in Connecticut called State versus Reddy, and it went to the appellate court. This is back in 2012, and it actually involved the risk warrant statute as well. And under the risk warrant statute, you get a hearing, shall have a hearing within 14 days of the execution of the warrant.
Right.
So, given what Ed said previously about the common practice in Connecticut now, since that other appellate court decision, where the police officers take the guns, put them in their evidence room, and then go get the warrant, and the warrant allows them to get them out of the evidence room, does the 14 days begin to run from the time they take them from the person, or from the time the warrant's executed in the evidence room? Well, it begins to run from the execution of the warrant, which would be from the evidence room. So the due process, which says within 14 days after your guns are taken from you, basically, you should get a hearing, doesn't really work anymore.
Now it turns into 17 days.
It doesn't really work anymore because the police can take your guns. They're sitting in the evidence room, so what's the big problem? Maybe the trooper that's working on the case goes on vacation for 2 weeks. Nobody's picking up the slack. Comes back in 2 weeks, does the warrant, hands it into court, and that's when the 14 days begins to run. There's no time limit between the time when they seize the firearms from you and the time they do the warrant, so the whole 14-day rule is kind of bullshit.
I'm paying attention to my finger right now. I'm trying to straighten it out.
No, I told you should do that.
I know.
So let me look.
But okay, and you know that was Judge Hudak that did that. Okay, but what I'm saying is this.
No, we haven't even talked about what Judge Hudak did yet. That's
With
in
Reddy?
State versus Reddy. Yeah.
Yeah, with Reddy. Okay, but
Yeah.
hold on. But what I'm trying to say is this: is that people predicted that if this law was passed, it would begin to creep outside of its original intent.
Right.
Okay? Begin creep. California enacted it. California, you know, Connecticut was the model. And because Connecticut's risk warrant statute allowing police officers to seize property, I'm not going to call them firearms, to seize property from an individual or their home without a warrant, especially when there's time to get one, without a warrant has never gone before a federal court. I'm aware of no case in the state of Connecticut where the risk warrant application, or whatever,
The
process of serving risk warrants has never stood federal scrutiny. And I believe that it would not pass federal scrutiny because it really comes down to a matter not of the Second Amendment. It comes down to the matter of the Fourth Amendment. Because it's only a matter of time that if the government feels they're getting what they want by seizing without warrants in the firearm area, they'll start to seize without warrants in other areas. And now we've got body cam. We can't have body cams. Look, my God, look at what is happening in this country now that there's body cam. Now that there's cameras focused on not just law enforcement activity, but anybody's activity. Now we have cameras. People don't like them. You know, I maintain that a police officer today is more fearful of a camera than they are of someone with a firearm.
And in the risk warrant statute, the way Connecticut's trying to amend it now in the 2021 legislative session is it used to be if you went to a hearing and the judge found in favor of the risk warrant, then you would not get your guns back for a year.
Yep.
And
Or they want to extend that too.
And applies to guns and ammunition and electronic defense weapons. Now, when that period expires, you're going to have to apply to get your firearms back and prove that you're not crazy.
A danger to yourself or others.
Right. Well, I'm just saying crazy because isn't there? I mean, what was it? If anybody who says they're crazy, I don't know. There's something like that. What's that saying? It's hard to prove you're not crazy. In other words.
Right.
Because crazy people say they're not crazy. But anyway, so you have to prove that you're not a risk to yourself or others. And if you're not able to do that, then you have to wait another 180 days to attempt to get your property back again. So they're trying to change it to that, putting the burden on the person to burden of proof on the person in order to get the firearms back.
Yes. And I don't know whether we're going to ever get to shall and may. But
well, I could read it right now. So I'm going to read from State versus Reddy. This is the case that talked about the risk warrant and how and the 14-day mandatory nature of the hearing after the seizure. So the court says, at the outset, we note that the use of the word shall in the statutes generally suggests a mandatory obligation. I agree with that. Do you agree with that?
Yes.
But you've heard differently, supposedly, right? You've heard that shall doesn't always mean it's mandatory.
Right.
And that's true. There are cases that say that. And a lot of them say, well, if it's jurisdictional and the court and it involves whether the court has jurisdiction or not, then it shall. But if it's not jurisdictional, then there can be some ins and outs of it, the way you can still, do something.
What did Hudak say?
This is the appellate court.
Oh.
So So in this case, Mr. Reddy showed up for his risk warrant hearing. He didn't have counsel. The state said they were ready to go. And it was within the 14-day period after the seizure. And the judge, the gentleman, Mr. Reddy, said, I'm not prepared to go. I've spoken to an attorney, or I've contacted an attorney, so I would like time for this attorney to be able to come in and represent me at the hearing. And Judge Hudak said that the statute says that a hearing shall be held within 14 days after the seizure. Not later than 14 days after the execution of a warrant under this section, the court for the geographical area where the person named in the warrant resides shall hold a hearing to determine whether the seized firearm should be returned to the person named in the warrant, or should continue to be held by the state. So the judge said, well, tough luck, because you're not going to get.
Got to have a hearing within 14 days.
It says shall. We got to have a hearing within 14 days. And Mr. Reddy appealed that through counsel, and the appellate court reversed and said, well, it does say shall, but since this was Mr. Reddy asserting his rights, he had the right to waive the 14 days and continue it. And now the hearings are, frequently continued, if not always continued, for people to be ready for them.
Let me give you another example. And this one is personal. And I'm going to say it. Up until the night of the 8th of April, I was on the board of directors of a condominium association in Rocky Hill, Connecticut, where I live. And there was an election to be held. My term was up, somebody else's term was up, and there were 3 candidates. The 2 people that their term was up, a woman named Elaine and myself, and there was a new woman, Mary Ellen, who was looking to get onto the board to replace either Elaine or myself. And I was having a pissing contest with Imagineers LLC in West Hartford, Connecticut, a prominent management company for condominiums and apartment complex or whatever. And I kept saying to the representative from Imagineers who was handling our complex, you're doing this wrong. The bylaws say,
right.
And what it says basically is, in the bylaws rules, in the rule, Article 2, Section 2.1, okay? If there's going to be an election of, they call it the executive board members, okay? You can't change the policy of electing board members. Only a vote of the owners can change the policy. I mean, I can't quote it off the top, right, but the only people that can change the policies on conducting an election are the owners.
Which makes sense, because the people who are subject to election probably shouldn't be making the rules about election, because they're incumbents and may gear towards their own reelection.
Right.
Yeah, so that makes sense.
In the same declaration and bylaws, it permits meetings by electronic, telephone, video. It permits to have meetings by video. But this was an election. By an electronic communication. It would have been permissible to change the policy and let people vote by email. All they had to do is get all of the owners to unanimously, 51%, agree that we're going to accept email ballots for our annual election of officers. They've never done that. This is the way it used to be. You come to the meeting, or you send in a paper ballot, and you can also send in proxies given to you by other members of the community to vote in their behalf. But you can't have more than 15% of the owners in your possession. You can't vote for more than 15%. So I called up earlier in the week and I said to the Destiny, the assistant to Sherry Kellner, I said, Destiny, I have to talk to Sherry. There's something that I need to talk to. We can't have this election on the night of the 8th. It's not proper. Tell her to read section 2.1. The board, the owners have never changed the policy to permit voting by email.
It wasn't even, we can't have the selection on the 8th. The agenda said the results were going to be presented on the 8th.
Oh yeah, not the election.
Right.
They're going to calculate the votes. They're going to calculate the votes before the meeting and announce the results at the meeting.
Right.
Now, you know, I've been the subject of absentee ballots when I ran for city council in Vero Beach, Florida. And the way you do it is this. You have a ballot sheet. 3 candidates. You check off the 2 you want. You fold it up and you put it into an envelope. You take the blank envelope with the unsigned ballot and you put it into another envelope and you put Peruta 37D, Peruta 37C, Peruta 37B, because we own 3 condo units. So they get sent in to the Imagineers. They're not opened, or you can open up the ballot that has Peruta 37C on it, but the unmarked envelope with the unsigned ballot is kept in the envelope. They're put in a pile. Nobody knows who those people in the pile are. You get to the meeting, you get a letter opener, and you have somebody count, and you open it up, tally, tally, tally the votes, tally the votes, tally the votes, tally the votes, and then you announce them. But nobody knows who somebody voted for.
Yeah, I mean, can you imagine, I think there's a Mrs. World out there, and it's been in the news a lot lately because whoever won Mrs. World, the runner-up, the former Mrs. World, had a problem with it and ripped the tiara off her head and injured her, I think.
Yeah.
And it was because she was accusing the recently, elected Mrs. World of actually being divorced. So, and she was saying you can't be divorced and be a Mrs. World, and then it turned into something, well, she's not divorced, she's separated, and that doesn't count. And so then the new Mrs. World came out in support of single parents everywhere, how it's a tough job, and, really turned the sympathy towards her. And I think they're going to arrest the former Mrs. World. But because, can you imagine in a beauty pageant, Mrs. World, Miss America, Miss Universe, whatever, if all the judges emailed their vote to one person, let's say the CEO of the pageant, and the CEO opened them all up and then came to the pageant and said, this person won. People be like, what? We're not believing this. We're not believing you. There's just too much room for mistake or error or intentional misrepresenting the results. And so you went to the hearing because I overheard.
I went to the hearing.
I overheard the Zoom
I tried
hearing.
to get on this Zoom thing.
Oh boy!
And I'm doing it on a phone, and I don't know whether anybody can hear me.
They could hear you,
but nobody was responding to me. In other words, Sherry Kellner could have announced, and I should have been able to hear, Ed Peruta has joined the meeting, because I joined 2 minutes late because I'm trying to figure out how to do it. Nobody said anything. So now my wife Lois is asking me, Ed, do you have your volume up or down or whatever? She was asking me something. And I'm trying, and then when I tried to do something, it logged me out, so I had to log in. All kinds of crazy
well,
shit.
I was driving, and I, went on to Zoom. I stopped, of course, went on to Zoom and put it there. So as I was driving, it was on, and all I could hear was
Lois!
Ed, Lois, can everybody hear me? Lois! Like he was lost out in the wilderness.
Yeah, because I could see her picture. I knew she was on, and I'm sitting there saying, "Can I hear you?"
And Cherry was like, Ed, we can all hear you.
Well, but tell them your first thought. You knew what was going on leading up to that meeting.
Oh,
and that's why you were going to the meeting, to witness what was going to happen, because you read the same stuff I read.
As soon as I got on the meeting, the first thing I really heard was the person from the
Sherry Kellner
from the property management company say, we didn't get enough votes, So we're not going to have the results. There's no election, and the current members are just going to go on. And I'm like, oh, that's a way to get out of this whole kerfuffle, huh?
Well, so then I asked, how many votes were cast? And she didn't answer
Somebody
me right
else
away.
actually asked before you. A couple people asked before you.
And then I asked her, I said, well, okay, in, I believe it's July of last year, they had an election to fill a slot. And my wife Lois was running. Mary Ellen, Ronnie was running, and somebody else was running. And Ronnie got 38 votes. My wife, Marie, got 16 votes, and my wife Lois got 13 votes. So my wife lost by 4 votes. Okay? But I said, wait a minute. I said, I need to know who voted. You know, how did this happen?
Which one? The current one?
The one back in July.
Oh, okay.
Because I said then, at the meeting, I was a member of the board, I said, wait a minute. You can't receive emails, look at who sent it, look who they voted for. You've got a tally of the votes 2 or 3 days prior to the election. All you have to do is call up somebody and say, look, we need a couple of more votes for Marie. Otherwise, Ed's wife's going to be on the board with him. Okay? And Sherry says, are you accusing me? I said, I'm not accusing you of shit. I said, I'm telling you, there's a flaw in the system that would permit someone to put their thumb on the scale and affect the election the way it's currently conducted.
It's often more the appearance of impropriety than actual impropriety, but it's because people are afraid to say anything that impropriety occurs. For example, Bernie Madoff. Something funny. Well, are you going to accuse him? I'm not going to accuse him. Maybe I'm not going to accuse him. Or a pilot and a co-pilot. The co-pilot's afraid to say anything to the pilot because of repercussions, so the plane crashes.
Right.
So you know what? It's not a matter of are you accusing me of something. It's a matter of things have to be put out there and dealt with.
Right. So, listen, I know we've got a phone call. I know that we had a phone call earlier that we didn't take, and I apologize. So if she's got somebody that we need to talk to,
Do you want to talk?
we'll come on.
Sometimes I think people just call to talk to Ariel.
You think
And
so?
they really don't want to talk
Does
to
somebody
the
want to
on-air
talk
talent.
to us?
It was JC.
Is he on the?
We
we
have
got
2
Midland,
calls.
Texas calling.
Uh-huh.
Which one do I answer first?
Choose.
Summary judgment.
Hi, this is Joe.
Hey, Joe from Midland, Texas. How are you?
Well, I woke up alive again, so I'm not a ghost yet, so don't get scared.
Where's Wade?
Well, he is taking a nap right now, leaving me in peace right now, which is one of the reasons why I called to say that I did not get to the bank because when he got back from his other grandparents, he was under the weather, so we had to take him to the hospital a couple of times to rehydrate.
Wow.
And, yeah, so he'd been a little bit under the weather. He never run fever or anything, but he was feeling really rough.
So it's not Wade. Wade's not old enough to report back to us, but Joe was going to report back to us about his visit to the bank on Monday that had to be canceled, I understand, and what the conversation was like or would have been like when he spoke to the bank officials about his privacy of his financial records, right, Joe?
Yes, ma'am.
Okay. So are you going to reschedule that visit for the future?
Oh, yes.
Okay. Okay. So we'll wait for that. We'll wait for news on that. Anything else from our
we
Midland,
were talking
Texas
about,
report?
Meanings of the words, shall and all that kind of stuff. And so I'm not an attorney, so nobody take this as he's been an attorney. But the shall, the original intent was in order to do a direct order.
Right.
However, what people have done now is taken different definitions from other countries and added to the word in the United States to give more authority to the government. Like person, there's 3 different definitions, and if you really look in there deeply, there's more than that. But legally, legal terms, there's 3 major definitions. And what they do with that 3, and as an attorney, what benefits the country the most is the definitions they use, not the definitions that we use on a day-to-day basis.
Joe, can I get your opinion on something if I say something?
Yes.
Okay. While everybody's talking about may, shall, can, can't, all that other shit, it came to me. I'm dating a beautiful woman. We're both naked and we're both in bed. And I'm about ready to make that move. And she says to me, you shall not put that inside of me. And I took it as, you may or you may not. What would the court say? Was that a command of the woman not to? You shall not have sexual intercourse with me. And I'm sitting there going, no, that means may. Maybe I can, maybe I can.
Well, I think that's a good example. I think that's a good example because one of the sayings that's come out of this, movement that you're kind of, of sexual assault and being clear in intentions is, men used to think that no meant maybe.
Right.
It used to be a joke, I'll put it that way. But now it's not a joke anymore. No means no.
Do you remember Mike Tyson got arrested for rape? He went up in a hotel room and got arrested for rape, right?
Yep.
At that time, there's going to be somebody coming to the door. I saw footprints. I said then, every man should have a card printed like a business card. Every man should have a card, and it should say, I, fill in your name with your date of birth, give Ed Peruta permission to have sexual intercourse and relations with me. Every man who is dating a woman and having sex should require the woman to sign a permission slip.
To have sex with you?
My wife is upstairs laughing. No, what I'm saying is...
Seems a little biased.
I said that years ago on Public Access. I said, Tyson should have had her sign a release. And then she comes down and says, hey man, had sex with me. But you know something? She gives me permission in the lobby. And
I just want to put a last word in. I think this is a good public service announcement at this point after what JC has said. Before you go look at documents, public documents, or before you request copies of those documents, look at the law.
Yeah, right.
To see what the law is so you're not overcharged. But it's not just a matter of not being overcharged like when you go to Walmart or something. It's a matter of the government abusing its authority and charging more for something than the law permits.
And it's happening right here in Connecticut.
Mm-hmm.
Listen, JC.
Yeah, hey, I'm not done. You said 7 minutes. I didn't get 7 minutes.
You go upstairs if you're excited. I'll talk to JC by myself. Go ahead, JC.
We had a situation where we just posted a video up on YouTube, a lieutenant talking to us about a stolen car, a burglary situation, that type of thing. And here's what's funny, is that after, when I first got there, the lieutenant was being a lieutenant, being a fucking cop. He was playing a cop mentality, right? And then I just kind of hung out there, and he kind of just got stuck with me, and we talked a little bit. And then he realized that, when one of his guys did something really good, like you remember when that vehicle blew up and I filmed it, I kind of called him and told him I was pretty impressed with how their cop handled that situation there.
Right. What department was that?
That's when, same one,
St. Augustine.
Department here.
Okay, just want to give credit.
Yeah, this time we're talking about the sheriff, right? So by the time we finished, when I first got up there, he gave me a soundbite. And, the soundbite is just an ass, and you can see it. So I sat there and I hung out, and I kept talking with him for a little bit. And when the smoke cleared, we got talking about training things and different things like that. And he's like, why don't you guys ever try to open up companies and just help train us versus sue us? I go, because every time we offer to come in and talk to you guys, your egos get in front of the way and you don't let us. You refuse us. We have volunteered our time to so many different police. We will come in and talk to your cops. But you guys turn us down. But yet we're the ones you're worried about. Don't you think you should at least have us come in front of your cops and go, hey, I'm so-and-so, so-and-so. If you see me, this is what's going to happen.
Yep.
This is,
Luke, stop.
I'm not going anywhere. You know, because now they know you as a person. Now they know you're there, why you're there. You know? So they shouldn't be running my tag and following us wherever we go and the things we do. It would free him up. But when I got done talking with the lieutenant, when the smoke cleared, he realized that I'm actually a pretty decent guy. And I looked down and I went, now you ready to do this right? And I threw my camera back on him. And he immediately went and gave me a real soundbite. The difference is on our YouTube channel, if you look at the comments, nobody's calling the cop a jerk. They're going, fuck, I like this guy.
And you know what that all comes back to, JC, and we're doing, you know, we're doing a complete circle here on the show because we began with this. Everybody should be judged on their own merits. The police officer shouldn't assume things about you because of what you're trying to do, and you shouldn't assume things about the police officer because of what he's trying to do, because that's where all the trouble starts. People should be given an opportunity, and if they blow that opportunity, then, you know, maybe they're blowing it for a reason. They got a chip on their shoulder and they can still be worked with. But I like that. I like working together because ultimately the goal is to hold government officials accountable, and if they're doing the right thing, then the goal's been achieved, right?
Right. Then the goal's achieved. They come out looking like heroes and godsend, you know, because everything's accomplished properly. And one of the things I explained to him, I go, here, I'll give you a quick training exercise. When you see a guy like me come up to a scene, okay, and you don't know who I am, what do you think I'm there for? I tell you, I'm with news. What do you think I want? I want 5 minutes of video. I want to film that. I want to film that sign. I want to film the skid marks. I want to film the car. No, I want to get the hell out of here so I can go to my next room.
You know what, JC, you and I will have to do this more often. Ed, we'll let Ed take a little break during shows, and you and I can talk one-on-one. But we've run out of time for today. We're down to 8 seconds. Everybody have a good week. Talk to you next week, JC.